The ground beneath your feet just shifted. We're not talking about proposals or bills that might pass someday. These are active laws, enforceable right now across multiple states, and if you're carrying a firearm for personal protection, the penalties for missing even one of these updates could cost you your freedom. 5 critical changes are reshaping the concealed carry landscape in 2026. Some are the biggest wins for the Second Amendment we've seen in 90 years. Others are legal minefields that could turn a routine traffic stop into a felony charge. And right now, there's an invisible clock ticking towards several major deadlines. If you don't know these dates, you're either going to lose a significant amount of money or worse, lose your right to bear arms entirely. Let's start with the headline everyone is talking about: the death of the $200 NFA tax stamp. For nearly a century, since 1934, the federal government has used a $200 poll tax on your rights to keep you from owning suppressors, short-barreled rifles, and short-barreled shotguns. In 1934, $200 was the equivalent of about $4,500 today. It was designed to be a financial barrier to entry, but as of January 1st, 2026, that barrier has officially been zeroed out. Under the 2025 firearms reform legislation, the tax for suppressors, SBRs, SBSs, and AOWs has dropped to $0. For the average concealed carry holder, this is a game changer. If you've been wanting a suppressor for your home defense handgun to protect your hearing, or if you've been looking at a compact SBR setup for your vehicle, the government just handed you a $200 discount. But here's the trap that's already catching people. The tax is gone, but the registration is not. Do not make the mistake of thinking these items are now over the counter like a standard Glock. You still have to file an ATF Form 1 to manufacture or a Form 4 to transfer. You still have to submit fingerprints and provide a passport photo. You still have to wait for the ATF to process your background check, which is still hovering between 3 to 6 months. If you're caught with an unregistered NFA item, the penalty hasn't changed. It's still 10 years in federal prison. The government didn't legalize these items. They just stopped charging you for the permission slip. And I've seen this question all over the forums. Can I get my money back if I filed in 2025? The answer is a flat no. If your paperwork was submitted and dated before January 1st, 2026, the ATF is keeping that $200. There is no retroactive refund. Some dealers are telling people to pre-order now, but be careful. The critical factor is the date the form is received by the ATF. If your dealer submits that Form 4 on December 31st to beat the rush, they just cost you $200. Make sure your purchase agreement explicitly states that the filing must occur after the new year. While everyone was celebrating the tax stamp removal, there's a federal enforcement change that's creating serious problems right now. On January 20th, 2026, the FBI activated a new nationwide concealed carry permit verification system. It's called the National Permit Status Database, and it allows law enforcement in any state to instantly check whether your concealed carry permit is valid, suspended, or revoked. Here's why this matters. Before this system existed, if you were stopped by police in another state, the officer had no reliable way to verify your out-of-state permit. That created a lot of gray area. That's over. Now, when an officer runs your ID during a traffic stop, your concealed carry permit status comes up automatically. They can see if it's active, if it's expired, if there's a suspension or revocation, and even if there's a pending renewal. This system is already catching people who didn't realize their permits had issues. Maybe your permit expired and you forgot to renew it. Maybe your state suspended it for a missed court date or unpaid fine and you never got the notice. Maybe you moved and the renewal reminder never reached you. Any of those situations could result in you being arrested for carrying without a valid permit. The penalties vary by state, but in most places, carrying with an expired or suspended permit is treated the same as carrying without a permit at all. In Texas, that's a Class A misdemeanor, up to 1 year in jail and a $4,000 fine. In Florida, it's a third-degree felony, carrying up to 5 years in prison. Here's what you need to do immediately. Log into your state's concealed carry permit portal and verify your status. Make sure your permit is active and that the expiration date is correct. If your permit is up for renewal in the next 90 days, start the process now. Processing times have increased dramatically in many states, and if your permit expires while your renewal is pending, you cannot legally carry during that gap. Update your address with your state's permit office if you've moved in the last year. Even if you updated your driver's license, your concealed carry permit is often managed by a different agency, and they don't automatically sync. Check for any holds or suspensions. Some states will suspend your permit for unpaid traffic tickets, missed jury duty, or failure to complete required training renewals. Now, while the federal government is tightening enforcement with databases, several states are moving in the opposite direction. As of February 1st, 2026, Louisiana, South Carolina, and Minnesota have all enacted constitutional carry laws. That brings the total number of permitless carry states to 30. Here's what constitutional carry actually means. You no longer need a permit to carry a concealed firearm if you're legally allowed to own one. No application fees, no training requirements, no waiting for approval. If you're 21 or older, not a prohibited person, and you legally own a handgun, you can carry it concealed in public. But here's what hasn't changed. You still cannot carry if you're a convicted felon, if you have a domestic violence conviction, if you're subject to a restraining order, or if you use illegal drugs. Constitutional carry doesn't eliminate those restrictions. It just removes the permit as a separate hurdle. Now here's where this gets interesting for people who travel. Just because these 3 states adopted constitutional carry doesn't mean your home state permit is worthless. Many states still require an actual permit for reciprocity recognition. So if you're from Texas and you travel to South Carolina, you can now carry there without a permit. But if you travel to Florida, you still need your Texas license to carry because Florida requires one. And even in constitutional carry states, there are still restricted locations. You cannot carry in schools, government buildings, polling places during elections, or private property where the owner has posted no firearms signage. Louisiana's law is particularly strict. They've added a provision that makes it a felony to carry in any place that serves alcohol for on-premises consumption, even if you're not drinking. That includes restaurants with a bar. The penalty is up to 5 years in prison and a $5,000 fine. Minnesota went a different route. Their law includes a carve-out for Minneapolis and St. Paul, which can still require permits within city limits if local governments pass an ordinance. So even though Minnesota is now a constitutional carry state, you might still need a permit depending on which city you're in. But while some states are loosening restrictions, others are creating entirely new barriers. Starting August 1st, 2026, Colorado officially implements Senate Bill 25003. This isn't just a tweak to background checks, it's a fundamental shift in how you acquire what the state now calls specified semi-automatic firearms. Don't let the name fool you. This isn't just about AR-15s. Under the new law, a specified semi-automatic firearm includes any semi-automatic rifle or shotgun that can accept a detachable magazine, and gas-operated semi-automatic handguns with detachable magazines. The only things largely exempt are rimfire .22s and recoil-operated pistols, which covers about 90% of the CCW market. But the moment you want a tactical shotgun or a modern sporting rifle, you hit the wall. Starting in August, you cannot simply walk into a gun store, pass a NICS check, and leave. You must first obtain a firearms safety course eligibility card. To get this card, you have to go through a multi-step gauntlet. You apply through your county sheriff and undergo a name-based criminal history check. You must complete a state-approved training course. If you haven't had certified training in the last 5 years, you're looking at a 12-hour extended course. If you have recent training, you might qualify for the 4-hour basic version. Then you must pass a written exam with a score of 90% or higher and demonstrate safe handling to an instructor verified by the sheriff. There is a silver lining. If you already own these firearms before August 1st, 2026, you're grandfathered in. You don't need a permit to keep what you have. However, the protection ends the second you try to buy something new. And if you're caught transferring without this permit, it's a Class 2 misdemeanor for the first offense and a Class 6 felony for the second. Here's the critical detail. The state's instructor list goes live in June 2026. If you plan on buying anything in the second half of the year, get your training done in June or July. Once August hits, the backlog for these classes is going to be months long, effectively creating a de facto ban on new sales due to bureaucracy. Now let's talk about something that's catching concealed carry holders completely off guard. Effective January 15, 2026, federal law now prohibits concealed carry in what they're calling enhanced security federal facilities. This isn't just courthouses and military bases anymore. The definition has expanded dramatically. Here's what now falls under the ban. Any federal building with increased security measures, including TSA offices, Social Security Administration buildings, Veterans Affairs hospitals, federal courthouses, IRS service centers, and even some post offices that share space with federal agencies. If there's a metal detector or armed security at the entrance, assume you cannot carry inside even with a valid permit. And here's the trap. The law applies to parking lots and surrounding grounds owned by the federal government, not just the buildings themselves. That means if you park in a VA hospital lot with your firearm locked in your vehicle, you could technically be in violation. The regulations specify that the restriction extends to all property under federal jurisdiction. The penalty is serious. Possession of a firearm in a restricted federal facility is a misdemeanor under 18 U.S.C. 930. That carries up to 1 year in federal prison and a fine of up to $100,000. And because it's a federal conviction, you could lose your gun rights permanently, even for a first offense. Before entering any federal facility, look for posted signage. If you see a metal detector, turn around. If you're visiting a VA hospital or any federal office, leave your firearm at home or secure it off federal property. Don't assume the parking lot is safe. Finally, there's one more state-level change creating serious problems for travelers. Effective February 15, 2026, Illinois and Oregon have both enacted laws that give legal force to no firearm signage on private property. This fundamentally changes the consequences of ignoring a posted sign. Here's the old rule in most states. If a business posts a no-gun sign and you carry anyway, the worst that can happen is they ask you to leave. If you refuse, you could be charged with trespassing. But the act of carrying past the sign itself isn't a crime. Illinois and Oregon just changed that. Under their new laws, if a property owner posts signage that meets specific state requirements, carrying past that sign is an automatic criminal offense. Simply entering the property while armed is a crime, even if no one notices. The signs have to meet very specific legal standards. In Illinois, the sign must be at least 4 inches by 6 inches, must include specific statutory language, and must be posted at every public entrance. Oregon's law requires a pictogram of a firearm with a red circle and / exact statutory text and posting in a location clearly visible from outside the entrance. And here's the kicker. The law also applies to verbal notice. If an employee or owner tells you that firearms are not allowed, that counts as legal notice. The penalties are harsh. In Illinois, violating the signage law is a Class A misdemeanor for a first offense. That's up to 364 days in jail and a $2,500 fine. For a second offense, it becomes a Class 4 felony carrying 1 to 3 years in prison. And if you're convicted, you lose your concealed carry permit and your firearm owner's identification card. Here's what makes this dangerous for travelers. If you're driving through Illinois or Oregon with your concealed carry firearm and you stop for gas, food, or a restroom break, if that business has posted a compliant no firearms sign and you miss it, you've just committed a crime the moment you walk through the door. Pay close attention to every entrance you walk through. Look for signage before you enter any business. If you see a no-gun sign, assume it's legally compliant and leave your firearm in your vehicle, secured in a lockbox. Familiarize yourself with what a legally compliant sign looks like in each state. And if you are ever confronted by an employee or owner and told to leave because of your firearm, comply immediately. Don't argue, don't ask to speak to a manager, just leave. Let's recap your action plan. If you're planning to buy a suppressor or an SBR, schedule your NFA purchases for after January 1st to avoid the $200 tax. Ensure your dealer doesn't auto-file your paperwork early. Verify your concealed carry permit status online right now and make sure it's current. If you live in Louisiana, South Carolina, or Minnesota, you can now carry without a permit, but keep your permit active for reciprocity. If you're in Colorado and plan on buying after August 1st, get your training certificate in June or July. Avoid carrying into any federal building with metal detectors or armed security. And if you travel through Illinois or Oregon, pay attention to posted signs. These aren't future changes. These laws are active right now. And the enforcement isn't theoretical. People are already being charged under these new rules. The landscape has shifted, and what was legal last year might land you in jail today. Stay informed because 2026 is just getting started.